I have to say one thing, I remember this so vividly. Before the curriculum committee meetings, the whole founding faculty went off to the ALS to recruit our first jointly selected faculty. So Irwin pretty much invited the founding faculty. And then we all went off to Washington together to hire the second group. And I remember we were having dinner together, and Irwin had a little napkin, literally, you know, when people talk about drawing up new plans for something on a napkin. And we talked together about doing what we have done so far, and that is each first-year course being called some different form of legal analysis. So statutory analysis turned into be criminal law, looking at the model penal code and various statutory provisions. Procedural analysis, which is my old field of expertise, how to analyze different processes that might get used. And I think we had pretty good buy-in to that idea that instead of just a diet of common law subjects where everybody in every single course just read cases and cases and cases, that we would try to do something a little bit different about training the legal mind differently in every class. So I think on that issue, I mean, we're all pretty much together on that, and I still think that was a terrific idea. The conflicts that I remember, as there were some, there should be in the beginning of anything, was about whether there should be an elective or international law, and the international law people won that. If I remember this correctly, my good dear friend Rachel Moran, who was here at the beginning and then went on to be dean at UCLA, I think she was a strong proponent of the elective approach. So we had people that were of good intentions and old friends, and she and I have both been leaders in legal education, and on that issue we differed. We agreed on some others, but the discussions were really quite good. Irwin did have a plan which at the time I agreed with. Having been a consultant when CUNY, the new law school in New York, was developed, CUNY reinvented all the courses completely. It was a fabulous program, but they all had different names. And then CUNY learned when the first group of students graduated, that they had resumes and transcripts that didn't have traditional law courses. So Irwin and the rest of us decided that we wanted to do innovative things, but we didn't want to look so out of the box. That's one of my phrases as a negotiation teacher. Usually I say think out of the box. But here the idea was not to think so far out of the box that our students wouldn't be recognizable as well-trained lawyers. And I think we really came to a very nice, even place there of doing innovative things inside the courses, giving them slightly different titles, but after the colon, it still said criminal law or civil procedure or contracts or torts, so that people would understand that our students were still getting basic legal education as well.